The Act was signed into law in November 2013. This doesn't mean it applies yet. We're still waiting for the President to give it an effective date. From the time it becomes effective, we'll have 1 year for everyone to ensure that they're compliant with the Act's requirements. What we've been encountering a lot recently is that our clients seem to think that POPI, as we call it, is a human resources department issue only. Well, I think this is quite a misconception. POPI is an organization-wide responsibility. It's not just the HR department that needs to deal with it. It's the supply chain management department. It's the people who deal with your clients. It's also your IT department's responsibility. What we found is that HR departments are simply saying this applies to our employees only, are making employees sign addenda to their employment contracts, and then they think they've complied. So why is it an organization-wide issue? It is because each of the relationships you have are impacted on by POPI. Your relationship as far as procurement is concerned, you need to go to your suppliers and you need to ensure that as far as their businesses are concerned, they are POPI compliant. Why is this? This is because POPI says that if you give any personal information to a third party, perhaps someone who's processing your payroll, the fact that they might breach the provisions of POPI means that you are just as liable. So you need to make sure that you've reviewed all your agreements with your suppliers to ensure that they give you undertakings that they are complying with POPI, especially provisions relating to the security in which, or the way in which they hold personal information. Why is POPI relevant to your relationship with your clients? Well, you might have agreements in place with your clients that don't deal with the protection of personal information. If something goes wrong, you could be in deep trouble and could be in for huge damages if you breach a client's personal information. So what should you be doing? You should ensure that the agreements that you have with your clients have terms and conditions that include indemnities and warranties from both sides, in fact. You should also try and have a limitation of liability clause in your contracts with your client, so that if something does go wrong, you're only in for a particular amount. Lastly, as far as your clients are concerned, you should make sure that if you are processing personal information in another jurisdiction, that you've obtained their permission to do so, and that you've told them that you will be processing their information in a jurisdiction that could possibly not have the same level of protection as South Africa has. As far as your IT department is concerned, you need to make sure that your IT department has assessed your systems to make sure that as far as security is concerned, you have reasonable levels of protection in place, because that's what POPI requires, that you keep information in a secure manner that prevents its destruction, its theft or exposure to third parties. So in essence, look at your organization and assess across the board whether you are compliant. Our suggestion is do a review or a gap analysis of all different departments to ensure that you're adequately taken care of and that you're compliant. Don't leave it for the last minute. Take care of it now.